Hey everyone, I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut, and today I'm going to break down custody in Connecticut Family Court. Custody can be complicated, but it's of course important because it affects your child's day-to-day life as well as big decisions about their future. Now in Connecticut, there are two main types of custody. There's legal custody and physical custody. Legal custody is about making major decisions for your child, things like their education, healthcare, and religious upbringing. Physical custody, on the other hand, is about where your child lives and who takes care of them on a daily basis. Let's start with legal custody. In almost all cases, legal custody is joint unless there's a compelling reason it shouldn't be joint. For example, one parent might be unfit to make decisions, may not be involved in the child's life at all, or the parents may be unable to cooperate to the point that somebody needs to have final decision-making authority. Now, in these difficult situations, one parent might have sole legal custody, or the parents could have joint legal custody with final decision-making assigned to one parent. That latter situation means they try to work together on reaching decisions, but if they can't agree, one parent has the final say. This is different from the former situation of sole legal custody, where one parent makes decisions entirely on their own without consulting the other parent. Now, when the court decides legal custody, the focus is always on the best interest of the child. Some of the factors courts consider include the child's relationship with each parent's ability to make responsible decisions and cooperate with the other parent, and the child's age and specific needs. Now, moving on to physical custody determines where your child actually lives. Like legal custody, it can be joint, also called shared, or one parent can have primary physical custody. Shared physical custody means the child spends roughly equal time with each parent, and if custody isn't shared, the child lives mostly with one parent while the other parent usually has visitation, also known as parenting time. Now, when determining physical custody, courts consider factors such as the child's stability and daily routine, each parent's living situation and ability to care for the child, the work schedules and flexibility of the parents, and the child's preferences if they're old enough to express them. Now, a common shared parenting plan might be that the child spends every Monday through Wednesday with one parent, then every Wednesday through Friday with the other parent, and then the parents alternate the weekend of Friday to the following Monday. And then a common non-shared parenting plan might be that the child lives primarily with one parent and the non-custodial parent has an overnight visit or a dinner visit once per week, and then the parents alternate weekends from Friday to Sunday or Friday to Monday morning. Now, the key is creating a plan that meets the child's needs first, although the parental convenience is also considered by the courts. So how are custody decisions actually made in court? Before going to court, parents are often encouraged or sometimes required to try mediation or another form of what's called alternative dispute resolution to reach an agreement on legal and physical custody. This involves the parties meeting with a neutral third party who facilitates a conversation and tries to help the parents reach an agreement. Now, if they're unable to reach an agreement, the case goes to court and a judge ultimately makes a decision. Judges will consider the proposed parenting plans from both parents, evidence of each parent's ability to care for the child and cooperate with the other parent, and reports from neutral third-party professionals like a guardian ad litem or family relations officer who will review the full family dynamic and make recommendations to the court about what legal and physical custody orders should go into effect. Now, judges have broad discretion and always make decisions based on what is best for the child. Now, custody orders aren't necessarily permanent. Either parent can ask the court to modify the custody orders if there is a substantial change in circumstances. Examples of a substantial change in circumstance might include a parent moving far away, changes in work schedule or availability, concerns about the child's safety or well-being, or the child's evolving needs as they grow older. Courts are looking for significant changes, not minor disagreements or small preference changes. So here are a few tips for parents navigating custody. Keep communication focused on the child, not conflicts between parents. Document schedules, agreements, and important interactions. Attend mediation and court hearings prepared, and consider professional help from a family law attorney, mediator, or parenting coordinator. Remember that the ultimate goal is always to reach an agreement that is in the best interest of your child. So those are the basics on custody here in Connecticut. As usual, if you have any additional questions, you can contact our office. And if you're looking for representation in a divorce or family law case here in Connecticut, we would invite you to contact our office as well.